Greetings, class. Welcome back to Business Law 1. Today we're going to be looking at Chapter 11, which involves consideration. As you may recall from our previous chapters, we're slowly kind of winding our way through understanding all of the elements that are necessary for an enforceable agreement. So we've discussed offer and acceptance. Sometimes those are coupled together and referred to as mutual assent. The next kind of like variable in the equation to determine if we have an enforceable agreement or not is consideration. Remember, consideration, I mentioned in the last chapter's discussion that it does need to be mutual, and we'll kind of go into that in a little bit more detail with today's discussion. And then we'll be in subsequent chapters, we'll be looking at the idea of the legality of an agreement, and then the capacity that the parties who have entered into the contract understand the nature of their rights and obligations. So the learning objectives that we have for this chapter, I want us to be able to understand what consideration is in contract law, obviously the role that it plays. We'll talk about the sufficiency of consideration, because sometimes that is an issue that arises in a contract. We'll talk about common situations where an understanding of consideration is important to have. And then we'll talk about, like with anything law related, there's certainly going to be exceptions. And so we'll talk about when a promise can be enforceable, even when there has been no consideration conveyed by one of the parties. So that's big picture, what we hope to achieve by the completion of our reading and our discussion for Chapter 11. So just as a general principle, when we talk about consideration, if you look up online or if you look in different textbooks, different authors, different persons of interest, have different ideas and different ways to explain what consideration is. For me, how I best kind of sum up and explain what consideration is, it's something that you're giving up that has value in exchange for something else that you feel has comparable value. And I know that may sound kind of vague, and maybe some examples, and I'll provide those in just a few minutes, but some examples I think will help kind of clarify that. But really the essence when we discuss consideration is, if we're in a contract together, whether it's, I'm contracting for a service or a physical good, it doesn't matter. Whatever I'm giving up, it has to be something that is valued by me and also by you. And then in the exchange process, whatever I am receiving from you equally has some kind of value associated with it. I always like to use examples that are more personal and relevant, for students. So when we go into the grocery store, because that's a common experience for all of us, as I've mentioned, everything on the shelf is an offer. When you pick it up and take it to the register, that's your acceptance. The consideration moment is when all of your items that you selected are being rung up at the cash register, bagged, and then payment is expected at that moment. So the consideration that you're giving up, or me, if I'm at the store, obviously it's payment, so whether I use a debit card, credit card, cash, traveler's checks, traditional check, doesn't matter, coins, that is what I'm giving up. And that is acknowledged under the law and by just societal norms as having value. What I'm getting that has been bagged for me, then that's obviously, like food or whatever else I purchase, beverages at the grocery store, that has comparable value. And that's what I really want in this transaction. If I'm hungry, I can't eat my debit card, I can't eat cash, but I can eat food. And, if you're the owner of the grocery store, you have plenty of inventory, and what you would prefer to have is plenty of cash or cash equivalent. So you see the nature of what that transaction is. Change the example and kind of show you how there are limits to consideration if it's not mutual. So if I make a blanket offer to anyone, I will give you $1,000, and that's all that I say. Certainly anyone who hears that would probably accept that. Sure, I'll take $1,000. If I say, okay, fine, I will deliver to you $1,000 tomorrow, and so that's the end of the conversation. Let's let's say tomorrow, comes and goes and you never see me, and you contact me and I just say, I changed my mind. So you decide you want to sue. We live in a litigious society, so that's fine. If you seek legal counsel, your attorney will tell you this, or if you just go to court and try and represent yourself, pro se, the judge will explain this to you. If I didn't expect you to do anything for that $1,000, then in essence, what I was offering you was a gift, because you didn't have to do anything for that $1,000. And because of that, that's not going to be an enforceable promise, because you didn't have to do anything. Now, if there were strings attached, if I said, well, I'll give you $1,000 if fill in the blank, you have to do something, then now we're getting into the realm of that's probably going to be construed as mutual consideration. And then if I fail to perform, then I have violated, the terms of our agreement. But at its essence, the idea of consideration is that it is an exchange that occurs of different items of value. If I want a TV from Best Buy, in my mind, I'm like, okay, I'll give currency. I want the TV because that has an associated value. If you have a lawn mowing business and I need my lawn mowed, obviously I'm paying, consideration on my end, and the consideration you're giving up is your time and your physical labor in order to kind of complete, whatever it is, the lawn, mowing activity that I'm hiring you to do. So whether it's for goods or services doesn't matter, as long as we can articulate and demonstrate that there has been an exchange of value that has occurred. So a promise is not binding if there's no consideration for the promise. So just as the example I gave with $1,000, if you didn't have to do anything in exchange for that, then we're not going to say that that's enforceable at that point. There is an exception because, again, the law obviously has lots of exceptions. There is an exception if you are a charitable or nonprofit organization. In that instance, if I make a pledge, to donate to a particular charity or religion, doesn't matter, nonprofit, and I decide I don't want to do that and I back out, the charitable organization, they have as a public policy, preference, they can sue me if they so choose, and I can't, kind of argue in response, well, they didn't give any consideration on their part. They just, are a charity. We want to encourage people when they make pledges or offer donations to nonprofit organizations for whatever purpose. We want to make sure that they follow through with that. So, the nonprofit in question would have standing in order to sue them for whatever that pledge is. Now, that's the legal theory. I always like to try and explain, the legal theory versus the reality. The reality is, if I was going to donate $1,000 to, let's say the Salvation Army or the Red Cross, and then I, for some reason, back out of that promise, they're probably not going to sue me over that, because it's, when you think of court costs and attorney fees, it's probably not worth it. But if it was, maybe a much larger donation, maybe I was donating, to, like the Red Cross, maybe $1 million, and they were going to rely on that to maybe provide relief for fill in the blank, some part of the world where there's a natural disaster or war or famine or whatever. And if I back out, then, they've already maybe made contracts or they've made agreements in furtherance and in reliance upon my promised donation. So then they might have an interest in seeking litigation to compel me to kind of pay up as what I promised. So, again, we do have, there's a lot of nuances and variations to this notion of what consideration is and how it's a requirement normally in contracts, but then also how there are exceptions. If we're looking at the adequacy of consideration, normally judges don't want to question how we assign value for whatever it is we're contracting over. Judges, normally they're not business persons. They're certainly well educated, and they know enough about business in that sometimes, maybe what is assigned value for something is not necessarily its true value. It's maybe the perceived value at that moment. To give you an example, if I have a car dealership, and so it's fairly early in the year, but let's say it's like we're getting into the fall, into the winter, so like October, November, December, end of year. A lot of times as you get near the end of the year for, like let's say if it's vehicles or it could be appliances or anything that has like an annual kind of rotation of inventory, I'm going to be motivated to try and unload that inventory because I know at the beginning of the coming year, there's going to be new models of vehicles that's going to be rolled out from the manufacturer. So even though there may be a stated value for the cars, I may have a motivation to discount it on some level because I need to make room for this new inventory. So a judge isn't going to tell me if I enter into contracts with whoever wants to purchase these vehicles at a discount. A judge isn't going to question me and say, well, why did you charge less for this? You could have charged more. Normally, judges do not even want to entertain that notion of adequacy of consideration. The only exception is that if there is such a gross disparity where maybe we're alleging there could have been some kind of fraud or some kind of unconscionability associated with the value of something, then perhaps we could delve into that adequacy and the notion of that. But unless we're arguing that kind of facet of this case, normally judges know that sometimes you discount stuff just to move inventory, and that's just a byproduct of doing business. Special situations involving consideration. So forbearance, if you're refraining to do an act that you have a legal right to do, that is considered a valid form of consideration. There's a problem at the end of this chapter that I'm going to go over. It's based on a classic contracts case from the 1890s. The original case is a case called Hammer v. Sidway. And I'll talk more about it when we get to that problem at the end of the chapter. But suffice to say that, in our common law system prior to this case, if you gave up the right to do something that you had a legal right to do, that used to not be considered consideration in a contract. But the result of that case, Hammer v. Sidway, we now say that if you have a right to do something under the law and you forego that right as part of what you negotiated in a contract, on your end, that's consideration at that point because you have a legal right to do it. The other special situation, the next one, is pre-existing legal obligation. So if you are already under contract to provide a service, you can't double dip. That's the best way I kind of think of this and can explain this. You can't double dip and expect to get paid twice to do the same thing. There's no basis for that. So if you're already being compensated to provide a service or perform whatever the function is, you can't expect someone else to pay you essentially for the exact same thing. You have to do something different. You have to augment your service. You have to provide some supplemental consideration that was not part of the original agreement if you're seeking to get some kind of compensation. The last one's a fascinating one. It's past consideration. Every contract that you enter into contemporaneously, so in the moment, is present and forward-looking. So, the fact that you might have done something, an hour ago, a day ago, a year ago, a decade ago, does not matter. That's history. We're never, we don't have a time machine. We can't go backwards in time. We can only look at the present and go forward. So for contractual purposes, if you have this notion of consideration, it has to be something that you proactively do either now or going into the future. Great example, this happened years ago. An outgoing CEO, so this person was retiring. This CEO had an executive assistant who had worked for the corporation for over 20 years, so long-term employee. And the employee was nearing retirement also, but this person was about 2 years out. So there was still some time left. The CEO was leaving within a month. And the CEO thought it would be a nice gesture to kind of instruct HR to tell the assistant that this person can basically, stop coming to work for the next 2 years. They'll still get paid every 2 weeks like normal. And then at the end of the 2 years, they'll stop getting paid, and then that's when they'll officially retire. But the reality is the CEO wanted to kind of offer this person, because of all their years of service, essentially, 2 years of, free compensation or pay, and then they would retire. So, okay, so, that's fine. The CEO goes off in the sunset, they're gone. The assistant is now just stays home and is, essentially retired. Every 2 weeks for a few months, this person's getting their paycheck like they would have had they shown up to work. Well, the new CEO comes on board, and it takes a couple of months. You get to know the lay of the land. You find out who's working in what departments, and the CEO happens to notice that there is someone on the payroll who is not coming to work. And so, he inquires with HR. HR explains the agreement that was drafted, and the new CEO said, "Well, I want you to stop paying this person because this person is not working." So, okay, so the 2 weeks goes by. The assistant who's now staying at home, thinking they're retired, is not getting paid. So they call HR. HR explains that they're just not getting paid anymore. So the assistant sues. Now we have a lawsuit. So the agreement that was drafted was essentially, we're going to still pay you, but you don't have to come into work. Well, it doesn't make sense. Why are you paying someone and not expect them to do anything in return? The fact that the employee had worked at the company for 20 years plus, that's great. They've been paid for all those years. So, we don't look at the past when we talk about consideration. It has to be present or forward looking. So we're kind of in this situation now where it's like, well, what do we do? And, the judge in this case, understands what consideration is and what is not consideration. And the fact that the employee did not have to do anything at all basically says, for those few months that you did get a paycheck when you weren't working, that was a gift. That's all it was. And you can't compel the company to continue to pay you if you're not working there. So the former, assistant who now thinks they're retired, but they really aren't, is out of luck. They lose this case. If you were the outgoing CEO, you could have done a couple of different things to protect your assistant from this problem. One, you could have just given the employee a lump sum payment. So, like for those of you that have had finance, that, you can extrapolate based on, the income stream over 2 years. You can reduce it to the present value and just cut the person a check. And at that point, you're done. And the new CEO would have had no control over that once the check was cashed. It would have been a done deal at that point. The other thing the outgoing CEO could have done was to say that, in light of your years of experience here at this company, over 20 years, what we're going to have you do is, as we bring on new employees, or maybe during tax season, we'll have you come in and, either help train new workers or just help prepare the books so that we can submit our taxes for the IRS. The new CEO, would have read that if that was part of the agreement, and probably would have just said, tell the person to stay home because this is aggravating. We know that, we're not going to question the adequacy of consideration, but, the former assistant had to have done something to be able to earn, quote unquote, those paychecks for 2 years before they eventually retire. But again, none of that was in the original offer. It was just because you worked here for all these years, we want you to have an early retirement. That's nice, that's great, but with the change in administration, with the new CEO, you can basically, if you understand consideration and contract law, you can say, well, there's, this person's not doing anything for these paychecks, so I'm not going to pay this person. So a very valuable lesson. If you ever find yourself in that situation, make sure you have something in writing that says you have to do something, even if it's very modest. We're not going to question the value of your consideration, just the fact that you have to do something in order to earn that consideration that's being given to you. I mentioned charitable subscriptions, so that's obviously an exception. The other exception is something called promissory estoppel. Sometimes that's called detrimental reliance. The idea with detrimental reliance is that you're already in a contractual relationship, and someone, the other party is making a promise or an offer, that usually does not have consideration. It's, hey, I know we're already doing this, as our agreement, but I'd like for you to do something in addition to that. And so if you do that, and you rely upon that, and you suffer a loss then at that point, then we're going to say that you have the ability to recover. The great example of this is Chrysler and Lamborghini. In this particular case, Chrysler v. Lamborghini, both are car manufacturers. Obviously, if you know anything about cars, you know they make very different types of cars. Some are, Chrysler, affordable, and then Lamborghini, not very affordable, very high-end luxury type vehicle. And so, Lamborghini production, over the years is very limited. We're talking about maybe a couple hundred of vehicles that they can kind of produce in any given year, very restricted. Chrysler, on the other hand, obviously they produce thousands of vehicles, so they have the skill set. Their kind of, wheelhouse is mass production. And what Chrysler was contemplating, they decided to purchase Lamborghini, and what they wanted to do was to develop a less expensive model of Lamborghini so that it would be more affordable. And if it's more affordable, you're going to sell more units. So that's the theory. So after they acquired Lamborghini, they approached dealerships around the world. And this was either in person, like they would visit, dealerships, like any manufacturer would, or sometimes they would have maybe conferences where they would pull together dealerships and kind of discuss issues that maybe are of importance to them. And so Chrysler made representations to all these dealerships that what we would like for you to do is to expand your showrooms, hire more mechanics and staff, increase the physical area of your property, so acquire more land because you're going to need a larger parking lot for more inventory of vehicles. And because we're going to roll out these more affordable versions of Lamborghinis, and you're going to be selling a lot more cars and servicing a lot more cars. Well, this one particular dealership, Chapel Lake Holdings in the UK, listened to the pitch, and they're like, we're on board, So they actually borrowed money, they expanded their location, they acquired more land, they hired more staff, they trained more mechanics, they did everything that was expected of them. And eventually Chrysler acknowledged that there were problems with prototypes and in the production, and so they just scrapped the plan altogether. So Chapel Lake now is in debt, in terms of, millions of dollars, and they go bankrupt. And their argument, they sue Chrysler, they say their argument is, we know we didn't have a contract to, kind of overextend ourselves by expanding operations, but we rely to our detriment on the promises and assurances that were made by Chrysler because we were already in this special relationship with them because they owned Lamborghini. And, the judge obviously agreed. This is a classic case where, if you rely to your detriment on the assurances of others that you already have a relationship with, then even if there's not consideration that's flowing in both directions, we're still going to say a contract exists to avoid injustice. And Chrysler was then ordered to compensate Chapel Lake and other dealerships that suffered similarly around the world. Great case, though, to illustrate detrimental reliance. So just a couple of problems to kind of flush out some of the details from this chapter. Sarah's house caught fire through the prompt assistance of her neighbor, Odessa. The fire was quickly extinguished. In gratitude, Sarah promised to pay Odessa $1,000. Can Odessa enforce this promise? Why or why not? And, in class, what I try and have students glean from this case is the element of time. So Sarah's, house is on fire. The neighbor comes out and, there's obviously some kind of an exchange. The neighbor helps put the fire out. And then once the fire is out, Sarah says, I thank you so much for doing this. I'm going to give you $1,000. And let's say that, an hour later, the next day, doesn't matter, Sarah changes her mind, says, I don't want to pay Odessa the $1,000. The time element here is that, since the fire had already been put out, it's in the past. Even though we're talking a matter of like seconds or minutes, past is the past. And so Odessa cannot force Sarah to make good on that promise of paying the $1,000. The only way you could do this, and there's a lot of issues, but the theory anyway is that if Sarah, her house is on fire, Odessa comes out, and Sarah says, Odessa, will you help me put out the fire? And if Odessa says, well, sure, but I want you to pay me, and then they negotiate, putting aside, undue pressure, or undue influence at the moment, that, you're not really thinking clearly, if you can put those issues aside, now at least, you're negotiating for, the neighbor, Odessa, to do something in the present or future, which is to help put out the fire. And now we have consideration. So the way this problem is worded like this, Odessa can't enforce the promise because she had already performed by the time this offer was made. So it's, past consideration is not consideration for a current or forward-looking contract. This is another great problem. Radio station has a contest that if you listen to our station and, we promise we'll play, I think it's at least 3 songs. And if you hear us play 2 or less and then have a commercial, the first person who calls in will give it $10,000. It's a great contest. They want you to listen. That's the goal of these kind of contests. And so Steve, he's listening to the radio station. He catches when they only have, when they only play 2 songs instead of 3 before a commercial. So he calls, claims the $10,000, and then the station says, we're not going to pay because, there was no consideration on your end. Again, I want you to try and understand that consideration takes so many different forms. It can be you physically doing something. It can be you providing a physical good, a service, whatever. In this case, the fact that Steve was giving his attention to the radio station, you may think, well, that's not really a lot of effort, but that is in itself consideration. So the station is obligated. They created the rules. They created the contest. And so, the fact that all Steve did was just listen and he happened to catch it and call, that is sufficient consideration because, again, we're not going to question the value of consideration generally. The last one here, this is the case that I had talked about, Hammer v. Sidway. So the names have been changed in this prompt, but essentially, this was from the 1890s. And at the time, an uncle had a nephew, and the nephew was, gambling, drinking, hanging around with a rough crowd. And at the time, he did have the legal right to do those things. The idea of like a 21 age drinking age is that's a 1980s kind of thing. It's not 1890s. So back in the 1890s, you could drink at a younger age. So he had a legal right to drink, a legal right to gamble, legal right, under the First Amendment of Association to hang out with a rough crowd. The uncle obviously was concerned about his nephew's future, so approached him and said, look, if you give up gambling, if you give up drinking, if you give up the, hanging around a rough crowd, I promise I'll give you, a bunch of money when you hit 21. So the nephew was like, okay. And the nephew followed the terms of the uncle's offer precisely. There was never any discussion or issue that there was a non-compliance. The nephew did what was expected that the uncle laid out for him. So the nephew reaches 21. And then the uncle says, look, you're doing great. And obviously the uncle, was financially successful. And so the uncle said, look, if you will keep letting me invest this money for you, for a few more years, maybe when you're 25, it'll be worth even more. So kind of like stay on the straight and narrow in life. And then when you hit 25, you're going to get even more money. So the nephew was like, okay, that's fine. In the meantime, the uncle passes. And so he's out of the picture. And his executor looks at the agreement and the executor says, well, this is not consideration. The fact that the nephew is not drinking and not gambling and not hanging out with a rough crowd, that's not consideration. And at the time, the courts did not consider that to be consideration. So to the executor's, kind of like, point, the executor was in, their interpretation was compliance with what was the expectation back in the day of consideration. So the nephew sues the estate, and, the judge in this case decided, and this is one of the great things with the common law, the judge can kind of recognize that maybe we need a new standard because of new things that are happening in society. And this case created this notion that, consideration can be the refraining of doing something that you have a legal right to do. And because of that, the estate had to pay the nephew the money that was owed as per the uncle's promise. Certainly, if the uncle had lived, this would have never become a case, and there might have been some other case that, where there was some sort of, forbearance of a legal right, as consideration. But the uncle passed, and the legacy of that agreement is now in the law that if you have a legal right to do something, that's the critical thing, and you forego that right to do that, then that can be consideration if that's what the other party to a contract expects of you. Anyway, I hope you've enjoyed this conversation on consideration. If you have any questions, as always, please feel free to reach out to me at any point. But have a wonderful, safe rest of your day, and I'll be chatting with you in the next chapter. Thank you.